U.S. citizenship for children. Options to get U.S. citizenship for your child. U.S. citizen or immigrant parents have three options to get citizenship for their child: acquisition of citizenship, derivation, or application for citizenship under Section 322. Derivation of citizenship and application for citizenship under Section 322. If you are a U.S. citizen or immigrant parent, figuring out how to help your non-citizen child gain citizenship can be confusing. The U.S. immigration laws have not been particularly kind, mainly because the basic requirements for seeking citizenship for children have changed so frequently during the past 50 years. Fortunately, things are not as complicated as they might look. The immigration laws provide for three main mechanisms that a U.S. citizen or immigrant parent can use to seek citizenship for their child, birth outside the U.S. to U.S. citizen parents. It's called the acquisition of citizenship. Citizenship or naturalization of parents. After the child has obtained a green card in the U.S., it's called the derivation of citizenship and application for citizenship under Section 322. Citizenship by derivation. If you are an immigrant who is eligible to seek naturalization and your child was born outside the United States, your child may be able to derive naturalization through your own application to naturalize. Even better, derivation works for children who have been adopted, including stepchildren whom you have adopted lawfully, so long as you and your adopted child meet certain requirements. Like with acquisition of citizenship, the laws have different requirements depending on when your child was born. In 2000, Congress passed the Child Citizenship Act, which removed some barriers in the legal requirements for deriving citizenship. The law says that for children who turned 18 years old on or after February 27, 2001, to derive citizenship through their parents, four requirements must be met. 1. One parent of the child is a U.S. citizen, by either birth or naturalization. 2. The child is under the age of 18 at the time one or both parents become U.S. citizens, and is not married. 3. The child is residing in the U.S. after being lawfully admitted as a permanent resident. And 4. The child is residing in the U.S. in the physical and legal custody of the U.S. citizen parent. For purposes of this article, we're assuming that your child was born recently or will soon be born. If your child turned 18 years old before February 27, 2001, the requirements for derivation are more complex. If your child is 18 years old before 2001, or if your child is adopted or is a stepchild, you should get more information and watch our next video to help you understand the various requirements. Derivation of citizenship means that, if your child meets all of the requirements, he or she is a U.S. citizen as a matter of law. Examples of citizenship for children through derivation. Example 1. The Lee family consists of 2 parents and 3 children. They live in the United States as permanent residents. Recently, Mr. Lee naturalized as a U.S. citizen. Automatically upon their father's naturalization, the 3 young children, all under age 18, immediately converted to U.S. citizens. Example 2. Mr. and Mrs. Jones were born in the United States and, thus, are U.S. citizens by birth. They adopted a baby girl from a foreign country. The child entered the United States as a lawful permanent resident. This child automatically became a U.S. citizen upon admission, as she then met all the requirements outlined above. Example 3. Mr. Reyes is a naturalized U.S. citizen living in the United States. He recently married a Filipino citizen residing in the Philippines. His new wife also has an existing minor child that is immigrating to the U.S. Unfortunately, the stepchild does not automatically derive citizenship in this situation. The stepchild may derive U.S. citizenship once his mother naturalizes as a U.S. citizen, as long as he is still under 18 years of age. If he reaches age 18 before his mother naturalizes, he can file Form N-400, Application for Naturalization, on his own. He or she will not need to apply for citizenship. However, your child can apply for a certificate of citizenship as documentation of his or her citizenship. To apply for this certificate, you and your child must complete and submit Form N-600 to U.S. Citizenship and Immigration Services. You will also need to provide evidence that your child meets all of the requirements discussed earlier. For more information, subscribe to our channel and watch our next video, U.S. Citizenship for Children of Naturalized Citizens, to learn more about this option. Citizenship by application. This also means that your child is not eligible to derive citizenship if you naturalize. Fortunately, you can still apply for citizenship for your child in this situation if you seek naturalization and fulfill some requirements. In some situations, your child might be lawfully in the United States, but not as a lawful permanent resident. This usually means that your child did not automatically acquire citizenship when he or she was born. Under Section 322 of the Immigration and Naturalization Act, the body of laws governing U.S. immigration, a naturalizing parent can seek a certificate of citizenship for their child if he or she meets the following requirements. 1. One parent is a U.S. citizen, usually by naturalization. 2. The child is legally present in the United States. 3. The child is under 18 years of age. 4. The child is in the legal and physical custody of the U.S. citizen parent. And 5. That U.S. citizen parent has been physically present in the U.S. for 5 years, 2 of which were after the parent turned 14 years of age. Note that the last requirement does not mean that the parent have been a citizen for 5 years, but that he or she must show overall physical presence meeting the requirement. For adopted children, the child must have been adopted prior to turning 16 years old in addition to meeting all of the other requirements in order to seek a certificate of citizenship this way. Parents serving in the U.S. Armed forces abroad may be able to waive the physical presence requirements. Parents whose children qualify for a certificate of citizenship under Section 322 must use Form N-600K. To apply, you will have to submit a completed Form N-600K along with strong evidence showing that you and your child meet the requirements discussed above. If you want more information about how to fill an N-600K application for your child, subscribe to our channel and watch our next video.